Thank you, Noah. I know the patient's wearing thin, but finally we get the man himself on the hot seat to be confronted. It's a real honor to be part of this whole conference. Noah, it has been just spectacular. Thank you for putting this together, Noah. What I want to do is let us start to talk about the book, hear from Robert himself about it. It has been a kind of extraordinary thing to watch the last stages of this book in production, up close and personal. So I just want to dive right into it. We're going to talk for about 30 minutes or so, maybe a little bit more, and then open up to questions from this amazing audience. So, Robert, I thought we'd start methods, talk content, and then maybe open it up to significance as a sort of three-part structure for the opening conversation. So talk to me about method. When I read this book, I feel a little bit like I'm reading the work of a student of Clifford Geertz, who has gone to a place, found an unlikely community, and has taken the time to study every gesture, ritual, linguistic practice. One thing that hasn't come up in our conversations very much yet is the tables and charts. There's this statistical structure to this book. There is no facts left outside this legal anthropologist's purview and gaze as you move through or study. So am I right about the anthropological, but talk to us about the methodological orientation you brought to this project, which is different from the other Holmes devices. It really is.
Thank you, John. And I just want to also extend my thanks to you and to Noah and to NYU and to Yale for this conference. The whole 2 days, I felt like Marshall McLuhan and Annie Hall. It's been the weirdest thing ever. And I can't tell you how moved I am by everything that's been said. Okay, so let's talk method. The first thing is I want to begin with what Noah said about Supreme Court history and just reading the text, and how one gets under a text and how one gives meaning to a text. So there are multiple. We were talking on the first day about multi-level, right? That was one of the local and the national, the international, the municipal, the state. In any causal explanation, and I don't even want to use the word causal, any explanation, any unpacking of these events, there are so many different levels of explanation that one could engage in. So the organization of the book is to start with a biographical understanding. You can't understand the play until you understand who the characters are. So the beginning of the book is to try to give a rich sense of who is there. But of course, in the court, they're not acting as autonomous individual actors. They're participating in an institution with its own norms. And then to sketch the norms of the institution, and then to put them in the play in different situations, whether it's prohibition or law and order or social and economic, and watch this interaction in these multi-levels. But I think you're right to think about it as anthropology. The way in which, I went to Harvard. I got a degree in American Civ. And I went to law school, and I thought, law school, what the hell? It's like you have one thing and you have another, and who's to say? So I really didn't have a voice in law school. Like, how do you decide these questions? And then I practiced, which I love doing because it's clean. You know what you're supposed to do, rip up the other guy. And then I went to teach, and it took me like years to find a voice. And the voice I found academically was to imagine that the law is an anthropologist. In these texts is an anthropological sense of what the world is. And if you unpack them, you get a vision of the world in which these people are living. So it's true what Marx said earlier about many of them, they're living in these multiple worlds, and of course it's messy and they're not clean. One of the reasons people like Brandeis and Holmes stand out is that they are clean. And so we remember them for that. These others we don't. But nevertheless, even in their muddledness, they are exemplifying the quotidian, the everyday understandings, and unpacking what those are the way a cultural anthropologist would. The way an Adam Civ person would read, a magazine article as, having an aesthetic form, just like Moby Dick has an aesthetic form. That's what was interesting to me in these texts, getting underneath and seeing the form and the thick description of what it was. So yeah, and how they respond to these problems and the menu of responses possible to these problems. So when you see that there's a menu of responses, typically the idea of law is it's ordered, it's inevitable, it's progressive, it's linear. But if in every situation there's a menu of responses, like human beings have a menu of responses, it's no longer legal in that sense, but it's legal in the sense that it carries the force of the state. So that tells you the multiple different dimensions in which state authority can splinter and yet be state authority. And then that poses the question of then how you reassemble it into something that has legitimacy. That's the whole idea.
So you're an anthropologist of anthropologists who have the power of the state.
Exactly so.
That's the
Some kind of meta anthropology.
yeah,
You know?
and the focus of your study has many different strands. The content, the symbolic content, the life worlds you find are multiple and in contradiction. That is to say, so one is this world of the customary order. The customary order that legitimates itself by something like spontaneous formation, your word, which is an interesting word, and maybe I'd like to hear more about it, but spontaneous formation, customary. There's another world that's, another life world here that's legitimating itself by reference to the production of economic goods, prosperity. Like, why this outcome? America will be richer for it. Another is America will be more democratic for it. And then last, America will have more law and order for it. So those are four very different organizing principles for a life world, for life worlds plural. Which is it, I guess, is what I want to ask. Is it four different worlds that are jumbled together on this funny institution, or is it one world with four? How do I think about that?
So I should say the thing that made writing, I've been working on this book for a long time, too long a time, 35 years. And the thing that allowed me to write it was Trump. Because like, Harding packs the court to turn it right, Trump is packing the court. But the deeper point was that I began to realize in 2017, we are living in a highly polarized situation. Highly polarized. So the question now for this court is, how do they ever say anything that the rest of us will trust as law, as opposed to, that's your opinion, you're just saying that because you're a conservative. Where does it get the impersonal authority that makes law law? That's the question that this court is wrestling with, and that's the question that the Taft court was wrestling with. They had just come out of the furnace of World War I, which upset everything that everybody knew about the American state. We had to become Prussia. And we had to compete with Prussia and being Prussian. And that, we were the state where it was individualism and laissez-faire and everything else. And suddenly there is this tide of revulsion in 1918. The Democrats lose the Congress and they're going to lose the presidency in 1920. And the court is kind of pell-mell denying, in one sense, everything that they knew had to happen. And on the other hand, as was said in the last panel, they also knew that they had these things and they had to do them for certain reasons. So they just didn't know what to think. They didn't know how to make a judgment that would have the impersonal authority. So it's a bid, it's performative when you're a judge in those circumstances, how to speak, and you're making a claim. I'm speaking with the authority of law. And I was able to see four different candidates. One was actually the traditional idea of law, which was law is a custom mediating consent. And that's when this point about Wickersham's speech, that great thing that you cited, the contrast between law and legislation, that was a staple of ABA rhetoric from the 1880s on. Mere legislation, they would say. That's what a group of people who happen to be hanging out at Capitol Hill do on a given day. But law, that's what all of us understand to be right and true, mediated by custom being consent. That was the traditional conservative, and it puts the emphasis on judges. And McReynolds, of course, with a vengeance, embodies that, but they all have it. A second bid was Taft, and Sutherland has bits of this, Pierce Butler does. The idea that what Americans want, more than they want whatever their legislators are giving them, they want to be rich. They want to have prosperity. Think of this in the 20s, right? They want to have the home that they can buy. So if we're protecting the rights that give them prosperity, they will go along with us as law because there's an agreement that's deeper about the need for prosperity than whatever a legislature happens to say. And that's, you think about the economic being prior to the political and neoliberalism. It was neoliberalism avant la lettre, and that's exactly what Taft is proposing. Quite explicit. He's very explicit about this. And then there was a third, which was Brandeis, and it was shocking to me. Brandeis says the political is prior to the economic. We're, first of all, bound by the fact that we're democratically connected and we want to express ourselves and govern ourselves. So the state has to create democratic sovereigns who are citizens. This we take for granted now. We take every law is democratically legitimate. So if you're going to strike it down as unconstitutional, there's always two constitutional values. Whatever right is being contradicted and the legitimacy that obtains to a democratic exercise of democratic will. That did not exist. There's no other justice who says that on the court. Whenever Brandeis says that, Holmes doesn't join him because he doesn't believe that. He doesn't have that sense of democracy. Thayer is the traditional deference. If you go back and read Thayer, he doesn't say a word about democracy. Doesn't say a word about the value of self-governance. It's Brandeis who imagines people as democratic sovereigns and creates a jurisprudence. Out of whole cloth, he creates that in the 20s. That's another bit and very isolated. And the final one, which we inhabit altogether now, is Holmesian positivism. He says, forget validity, the only issue is how do we avoid killing each other? How do we avoid another civil war? And we need orderly change, having a legislature that reflects what he calls dominant opinion is the only way that we can avoid killing each other, and that's orderly change. And we now call that, positivism, which is the ancestor of originalism. All of that is coming right out of Holmes. There are those four narratives of how do you make law.
So abstract themes, but connected to particular concrete people. Like that's another through line for this book. So I want to hear about some of the concrete people. Taft, you spent a long time with him. I mean, he comes off here. He is the fortunate son of America, with one grave exception: losing the election the second time around. So
losing,
yes. So Taft, tell us about Taft. I mean, he's sort of looming here. He is the brooding omnipresence for the last day and a half. So where are you on Taft?
Taft is a president. He gets elected, and he says, no more laissez-faire. He says when he's elected in his first inaugural. He understands himself to be a progressive. He's big in antitrust. He's big in conservation. He's a conservative progressive. So, we have to modify it that way, meaning he thinks you're going to get it through rationalizing business and business procedures. But he really does imagine himself as somebody who is adopting the latest techniques to make the most efficient form of governance for the United States. And I don't know the answer to Laura's question about why he fails it. The demands on him, he was not able to, because he actually hated trying to convince other people and sell his views. He couldn't bear that. That's why he liked being a judge, because when I speak, you have to listen. Whereas as president, if I have to speak, you may not be listening, and then what am I supposed to do? Plead? He didn't want to plead. And so he gets roundly defeated. He wins only Utah and Vermont in the 1912 election, and he becomes America's most famous lecturer. If you look in the footnotes, there's poems about him becoming. So people really didn't like him as president, and all of a sudden he's rehabilitated as this commentator. He's very frank and very smart, and people love him. And he also gets rehabilitated because he supports Woodrow Wilson for the League of Nations. So he goes and he's bipartisan. He might have been nominated as the Republican nominee in 1920, except he lost all the Republicans by going on the stage in Carnegie Hall with Woodrow Wilson, which is like, betraying the enemy. And so he's nonpartisan in that way, even though he's a deep partisan. And he also becomes chair of the National War Labor Board, which means he's working with pro-labor people and successfully recognizing unions, recognizing a right to a living wage, recognizing all of the rights that labor had been fighting for generations and never been recognized. It's the first time, and his work actually earns him the accolades and support of labor, who hated him because when he was on the Sixth Circuit as a judge, he invented the labor injunction that squashed strikes. So he was always like that anti-labor judge until World War I, when he realized you can't increase production unless you allow for a stable labor market, because the workers are off fighting, everyone needs a job, wages are rising, so they'll go for the next job with the higher wage, so they couldn't have a stable labor force. And so he said, the way you get a stable labor force is you have unions, you give them self-government, and he wanted the state to recognize unions. This is the group system that we're talking about earlier, and so labor was on his side. So along comes 1921, and he's this sort of nonpartisan figure, sort of like he's reached out to labor, and someone of tremendous integrity who has the energy of 15 men. I mean, everyone in the court is like astonished by his energy. There's a famous story about Brandeis, and when Brandeis gets nominated, Taft signs a letter with several other presidents of the ABA saying he's not fit to be on the court. He says, "Es ist zu lachen." It's to laugh that they would nominate this person he hates property. It's awful that, and he signs a letter against Brandeis, comes out against him, and then Brandeis tells the story. 2 years later, they're walking across what we now call Taft Bridge, Connecticut Avenue in Washington, and Brandeis sees Taft, and Taft says, "Mr. Justice Brandeis, I presume." And he puts his hand on Brandeis's knee, and he starts talking about how you rationalize labor forces. And then he goes up and he invites Brandeis up to his house, and they're talking to each other. And Brandeis said, "I had the most pleasant afternoon. I never thought I would live to see this." So he's a guy who has enemies. He knows how to reach out to the enemies. He never forgave Brandeis, because Brandeis, remember, in the Ballinger affair, was the guy who prosecuted Taft's Secretary of the Interior, and Taft thought he was wicked, and he continued to think he was wicked. I have a letter from Taft to Harding in March of 1920 saying, "I'll never forgive Brandeis." This is March 1920, 2 years after he puts his hand on Brandeis's knee and says, "Mr. Brandeis," and talks about him. So he's able to deal with these people in ways that are amazingly constructive. And he brings the perspective of a president to bear on the court, and he, for the first time, when he becomes Chief Justice, the federal judiciary is a bunch of independent district judges, each in their own district. He says, "No, we're an arm of the federal government, and we exist to serve a need, so we have to do it all together in an organized way. So if this district is too little work and that too much, we got to transfer people," right? This is a radical new concept, and it gets attacked by, for example, Henry Clayton says that's a military idea of judges, not the real idea of judges, right? Judges don't serve the state, and he says, "Yes, you do. You serve us because we have a need to settle disputes." Prohibition brings on that need. So he imagines the federal judiciary as a branch of government. Now the Chief Justice gives the state of the judiciary, right, like the president does. That's owing to Taft, right? Because he reconceives the federal judiciary with the Chief Justice as the head of the federal judiciary. He never had that before. Second, he reconceives the Supreme Court. He changes it from a court of last resort into the supervisor of the future development. So it's forward-looking, not backward-looking. He builds the Supreme Court building. He's just an amazing dynamo. And he is every week he's meeting with the president, or he's meeting with the chair of the Senate Judiciary or the House Judiciary. He's pushing bills. He's lobbying explicitly. He's writing secret memoranda, he's doing every day. It's like 15 things. It's the most amazing thing.
The book starts with appointments, and through the book there are references, comparisons to the Roberts Court. Some of the charts go up well into the 21st century to give a sense of how the Taft Court is initiating changes that then continue. And you just invoked Trump, so I'm thinking appointments compared to today. I mean, how do the appointments of the early 20s compare to the processes by which justices get appointed today? Is it a recognizable process? Is it a foreign process? Is it passed a different country on this score?
That's a good question. Well, of course, there's no Federal Society. There's no Leonard Leo, more to the point, back then. And I would say that the sense of agenda on the part of the executive, it's much coarser. Now, the executive is talking about What are you going to do on abortion? What are you going to do on this and that and the other? Back then, like Teddy Roosevelt, before he appointed Holmes, he said, I want assurances he's good on the insular cases. I mean, so they had tests back then of various kinds. But Harding, as far as I can see, didn't know from tests. He just trusted Taft. And Taft, Taft gets Butler. He's the one who finds Butler and pushes him through Vandervander. And he says about Butler, he says, we need a Democrat because the court has to be bipartisan. But he says about Butler, he's not enough of a Democrat to hurt. That's the way he put it. And he knew Butler was extremely conservative. And so he does Butler. Sanford actually comes more out of a guy named Fowler, who is a Tennessee assistant attorney general who convinces Dougherty, who brings him to Taft. Taft rules out Learned Hand. He rules out liberals from the northeastern states, so it goes to Sanford. And Taft is involved in virtually every appointment to the lower courts. I mean, to read this, it's astonishing. Before Harding will appoint a district judge in South Carolina who'll go to Taft and say, what do you think? I mean, really phenomenal. There's nothing like that now, and no justice now could be involved in the appointments in that way. It would be considered totally inappropriate.
If I said it was intensely all the way to the bottom political, but not partisan, would that capture the
There's a wonderful statement by Brandeis. He says, the only time I got into an argument, a shouting argument with Taft, the only time Brandeis and Taft had this argument, Taft is asking about Butler, and he says, it's really good, I got him, because he's a Democrat. That's nonpartisan. Brandeis is a Democrat, so he's appealing to Brandeis as being a Democrat. And Brandeis says, no. He says, what matters is the view on property, not whether they're a Democrat or Republican. And you're appointing people who are, have a certain view of property. And Taft says, what do you mean? We can't pick people on their view of property. Of course, that's exactly what he's been doing all the time, explicitly in the letters.
Great. So people, now moving to the content of some of the decisions and your interesting interpretations of them. You have a chapter titled The Realm of Freedom. The Realm of Freedom. And that captured to me the way in which a number of your justices in the way in which the Taft Court tries to craft a space after World War I, independent of the state, that will sustain both the customary and consent-based model, that will be the basis for the prosperity model on a different account. It has some resonance with Brandeis's democracy model, the realm of freedom. And yet, through the 20s, I mean, the idea that there's some realm of freedom, some space that is separate from the state, is an increasingly difficult thing to hold on to. That is to say, what I love best in the world is workers' compensation systems, and they are now pervasive in American life. The administrative state is in every place of employment, with labor and management's sort of willing signing on, but it's compulsory. Village of Euclid that we talked about yesterday means that zoning is now sweeping through neighborhoods. People's homes, the way they live in their neighborhoods, has now been organized by a proto-local administrative state. The professional managerial class has been moving its way through these conversations now for the last day and a half. They are re-engineering those classes, the world that everyone is living in. And so the idea that there's a realm of freedom independent of the technocratic, managerial, re-engineered regimes of the modern world seems kind of preposterous and extraordinary to be able to hold on to. I mean, how can Taft and company hold on to that idea in the face of just the rampant progress of modern engineering?
We do the same thing, Fifth Amendment rights, First Amendment right, it's like, of course, every culture values the thing it's losing. Right? This is what rights do. They're a symbolic expression of the things you think are under threat. And that was very true then, and this is precisely the function of World War I, that this was so regulated, and now we're going to draw lines. This is when Bill was talking about the rhetoric of reaction, that's really true, that there is a rhetoric, it's like this far and no farther, or I'm going to even push you back a little. In some areas, and in other areas, yeah, I have to recognize, but I'm ambivalent. It was very complicated and very muddy in precisely that way. But think of a case like Myers versus Nebraska, right? where the question is, can you forbid teaching of German? Like, who cares whether you can teach German? But on the other hand, it becomes a place where you draw an expressive, this is, Rick Pildesland, expressive rights, that you draw an expressive notion of you can't do that. And that case, as Jerry Gunther says, divides the left, because Holmes dissents, and Brandeis goes along with McReynolds. Brandeis and McReynolds both have an idea, for different reasons, that you can't go that far. And the interesting thing to me is to watch the cases which are unanimous, which say you can't go that far. Wolf packing is a case that almost nobody knows. But it's a case about compelled arbitration, and the court says you can't compel people to work, and Holmes joins it, and Brandeis joins it, and Holmes and Taft writes it, because that's something you can't do to people, but for different reasons. But they're constructing something. And the other point, of course, is when we think about the Taft Court, we think about this realm of freedom as economic, but in point of fact, it's not economic. It has to do with the rights that make you human, and these are continuous between liberty and property at the time. Now, after the New Deal, we've lost the sense of property being connected to personality, although with Robert Reich, right, and welfare, rights against welfare, we get it back a little bit, but just a little bit. For those people, property and liberty, they're part of what it is to be human.
The labor cases, just as you say, wolfpacking, are some of the main places we see the realm of liberty being deployed. But when you get into the labor cases, in some ways, and Noah's observations in the last panel went to this a little bit, the labor cases don't end up just being a full-throated defense of the realm of freedom against all other comers. So the two-step that occurs in the early 20s between, on the one hand, the Truax case, I'm probably butchering the pronunciation, the Truax case on the one hand, and Michelson on the other. So Truax is the full-throated defense of employer property rights as against an Arizona statute that has banned injunctions. It's kind of Norris LaGuardia at the state level before Norris LaGuardia. There, the Arizona statute struck down. Why? The realm of freedom, I'm extrapolating, the realm of freedom requires that employers be able to get the injunction to protect themselves in those fights with labor. On the other hand, the Michelson case is a careful navigation of questions about criminal contempt arising out of those very same injunctions, in which Taft finds a way for, on Robert's view, really quite political reasons to get to a pro-labor outcome. Two cases decided almost back-to-back. Right? What's the sequence?
1924, the other's 21.
Okay, and the 24 is the electoral context, that election. So realm of freedom or kind of like savvy navigation of political imperatives, that is to say the big abstract categories that we started with, life worlds organized around democracy or around custom, have given way to narrower, unseemly even maybe on certain views, political projects. How do I make sense of that?
Well, again, this goes to the question of how you explain something. There's multiple ways in which you can explain an action. I actually believe in the value. I need to do this because otherwise I'm going to be screwed. There's just many things that are going on in a case, and in any given case, you don't know what level of explanation to give. And in the Michelson case, it's really interesting that the court allows the Clayton Act to go into effect and say, if you're convicted under certain circumstances of violating a contempt of an injunction, you get a jury trial. And before it was equitable, so it was just before the trial judge. So the judge would have an injunction, you'd violate it, you come before the judge whose injunction you violated. He said, of course, you're defying me, you're going to jail. And so this reform was you need a neutral decision maker, you need a jury. So when Taft is president, he says, if you allow jury trials for contempt, it's just like Theodore Roosevelt saying that you're going to nullify constitutional law decision. He was adamant about this, adamant, and he viewed it as fundamental. His first term as Chief Justice, he decides 4 labor cases, by far the most controversial in the sense of spurring a political reaction. It's not party, it's labor capital. So he decides the child labor tax case, He decides Truax, which is, do you have a right to injunction? He decides the Coronado case, which says that labor unions are liable for damages. This was viewed at, it was said at the time, the greatest blow to labor in the history of the United States. So he decides 4 cases, and, another case about picketing and when you can enjoin violent picketing called Tri-City. So these 4 cases prompt calls for his ouster by the AFL. Labor unions are going crazy. They thought he was his friend after the war. And so he knows that labor is a really sore subject. And by 1924, he sees that labor has united with the farmers to support La Follette, that there's an election. He's writing letters to Coolidge saying, God bless you, sir. If you lose, civilization is at an end. Literally, he's writing these letters while he's deciding this case about, do you get a jury trial? And we know, I can't, there's not a case file on it, so I can't take you through the drafts, but I have a letter or two, and I can tell you, Sutherland writes the opinion. He takes out about 3 pages of Sutherland's opinion, in which Sutherland is saying, yeah, you can maybe do that, but you can't do this, this, and this, because that's the inherent Article 3 power, of course. And Taft says, let's not talk about our inherent power. Let's just say they can do this. And so they do it. They all voted in conference. By the way, when I did this book, Gail Galloway was at the time the archivist at the Supreme Court, and I got to go to the attic and find the docket book, so I can tell you how they voted in conference and how they changed. This was unanimous in conference, the Michelson case. So whatever it was viewed as not so controversial. I mean, typically in a case, if it's really controversial, they would have voted the other way. So what Taft is doing is not so much changing the outcome, he's changing the rhetorical dressing so that it seems like a major victory rather than you can go that far, but not this far.
So I'm going to put one more question to Robert and then open it up to questions from the audience. But it stems from Truax. One of the features of Truax is that it's an equal protection case before the world of equal protection that we recognize. It's an equal protection case around employers' rights to being equal under the laws. And your chapter on equal protection, your chapter on race, brings this out. It's a law of race that's unrecognizable from the perspective of today. And we saw some of this this morning in the panel with Kim and Megan and Magdalene, which was really quite striking. And on your account, the Moore against Dempsey case that was a part of our conversation this morning is actually not a big deal for the Taft court. It seems like a big deal to the historians, and I count myself among them, for a whole variety of reasons. But for you, the more important thing is something like, well, it's either Truax's kind of interesting equal protection approach that applies to states but not to the federal government, right? So that's kind of an interesting model, which doesn't end up getting pursued after Bowling against Sharp. But for you, it's the nomination of Judge Parker from the Fourth Circuit, which gets killed in part by the NAACP. It's an interesting convergence between AFL on the one hand, because Parker's an injunction guy, and the NAACP, who's resisting this Fourth Circuit nomination. And that failed nomination is the significant race moment in the Taft court for you. For reasons that I find completely fascinating and compelling. I think what I'll do is I sort of ask you to elaborate why it is that is the moment where you can understand race becoming part of American constitutional law in a way that Moore against Dempsey is not.
So remember that there's 4 stories about constitutional law? The story that dominates about race more than any other is the story of customs, usages, traditions. If you read Plessy, right, it's against our custom. The state can enforce customs, usages, traditions. That is a court speaking with common law authority, and as opposed to Brandeis's view or Trump's or Taft's view, or even Holmes's view, right? So the rhetoric of race was exactly the rhetoric of what are the customs of the people in the South. And the interesting thing about the Taft court, they uphold in Gung Lum, they uphold Plessy, unanimous. This is, Harlan Stone votes for this. Brandeis votes for this. Holmes votes for this. There is no dissent. There is no one on the court who is sensitive to race as a caste, race as a minority group that is stigmatized. There is no sense of that race. Brandeis has a sense of race as cultural ethnicity. He's a cultural pluralist. He writes a speech called True Americanism. He has no sense of race as a stigmatic caste. And if you look at the Equal Protection Clause during this whole period, it has no content whatever, except as it's caught into the other agenda items of the court. So they use equal protection to protect the national market. They use equal protection to protect corporations against, say, taxes of corporations, but not individuals. They use it to protect out-of-state as opposed to in-state corporations. So it's all used in that way. And as Holmes says in Buck versus Bell, it's the last argument of a scoundrel, you know, if you see an equal protection. There is no sense of equal protection because it's completely divorced from anything we would now recognize as what equal protection is about, which is the protection of discrete and insular minorities. So where does that come from? Well, there's a long story in the book about Taft and the Hampton Institute and his the challenges to the Virginia segregation law, whether it decided in his living room as the chair of the board of trustees. Really interesting stuff, which is very akin to what you were describing as the biracial commissions. That's the way they're imagining this. You need an alliance between Southern white elites and blacks like Washington to make this work. That was the Republican approach that Taft had, but everybody on the court had it. There wasn't anyone in labor. There were people speaking for the working class. It wasn't true in race. It was just striking. And then what changed that? And this was a total surprise to me. I just found it in the materials, and it was like being struck. So Sanford dies. He dies on Oliver Wendell Holmes' 89th birthday, and the same day that Taft dies. All happens on one day. He's in the dentist chair, and he stands up, and he gets delirious, and he drops dead. And so Hoover has to nominate someone to replace him, and he nominates John G. Parker, who is a very pro-employer judge. But on the question of race, actually, he also holds that Euclid had not overturned Buchanan, so you can't discriminate on the basis of race. But when he ran for governor of North Carolina, he did that on the grounds that, of course, blacks shouldn't vote. They're not mature enough to participate in politics. So White is the head of the Inc. Fund. He's, I think, acting head at that time. And he orchestrates a campaign against the nomination of Parker. So there's a number of things important to notice about this. One is the campaign appeals to black votes that have migrated north because of the Great Migration. And so it becomes clear that there are these black voters who are swing voters in about 10 states, particularly border states, and they're in cities. And they get mobilized. Now, I've seen traces throughout the 20s. Taft is very aware of these black voters, but everyone is imagining black voters as always Republican because it's the Republican Party, et cetera, party of Lincoln. They always imagine black voters, they're in the Republican Party's pocket. And Taft is always sending out things like, let's get black voters involved in this case to support the court because it's protecting their rights. So I've seen that throughout the 20s. But what happens is that White organizes it on the model of the Anti-Saloon League, which is the single most effective single lobby issue group in the history of American politics. It's that group which causes the Volstead Act to be the bone dry act that it is. It's that group which makes the life and breaks the life of politicians. And White uses them as a model for organizing votes, exactly votes. And they're telephone banks, and they're calling into their representatives. And if you read the papers at the time, they are saying the reason Parker gets defeated is because of the black vote. And people are saying this is the first time the black vote has exercised power since Reconstruction. It's the first time blacks have to be imagined as a political force in the United States. And it's interesting because, to my mind, the jurisprudence of the Taft Court is exemplified by, you all probably know Harding's speech in Birmingham, Alabama on the 50th anniversary when he says, America should be one, we should be one people when we talk about political and economic matters, no race. But when it comes to other matters, social matters, we're entirely separate. So this is like Washington, 5 fingers, 1 hand. And then he says, we've heard too much in political matters about the Swedish vote and about the Italian vote and about the Polish vote, but he never mentions the black vote, right? And suddenly the black vote is now on the table. And what that said to me is a group doesn't get the rights to be recognized as a political agent until they act as a political agent. Taft knew perfectly well, it's perfectly explicit in his letters and in his speeches and in his articles, blacks are being denied rights which they should have under the 14th and 15th Amendment in the South. He knew that. But he said you can't go against the customs of the people, even though he was willing under the 18th Amendment to override the customs of ethnic minorities in the cities. But he thought you couldn't do that in the South. And so basically that exiles blacks from the canopy of the Constitution. They don't have constitutional rights because they don't count, because they're not a political presence. Suddenly they're a political presence, and now, 8 years later, 7 years later, you get the footnote in Caroline Products that protects political processes and those who are acting as political agents, and blacks are at the heart of the conception in Caroline Products, and I think it's because they become nationally visible. At least I put that as an hypothesis. It's after my period, so I can't, nail it down, but I think it's a pretty good, there's something that happened there that's huge.
Well, so I love this story. I love the theory underneath it, which is that to get equal protection, you need to have a political coalition. Right? In some ways, it's at odds with the formal logic of Caroline Products, even as it's explaining Caroline Products. So that's kind of amazing. But this is the follow-up. I said I already asked my last question as a follow-up. The follow-up is, there's a way in which this move is at odds with the methodology of the Holmes Devises. The Holmes Devise asks us to look at legal history from the perspective of the court. And what Robert has just told us in this beautiful rendering is that actually constitutional law is an artifact of popular mobilizations that come from outside the court. That is to say, it's Walter White and the mobilization against Parker. They're in control, sort of, at least. They're shaping the moves that get made.
Yeah. Well, I mean, the court is always like in dialogue with these things, and so when we then teach it in the textbooks that Noah finds so boring, that's because they've recognized what the rest of us in our political mobilization have given them.
Great. Let's throw it open to the group. Andrea.
Formidable as a Chief Justice, but from the point of view of the law, the administrative state, and the presidency today, he has had such a deleterious effect. And I'm thinking specifically of the Myers case, 1926, and Hampton, 1928. In Myers, Taft discovers, this phrase "inherent power," which they were, circumspect about using vis-a-vis the court, but not about the presidency. Discovers a removal power in Article 2. Justice Holmes famously calls it spider webs inadequate to control the facts, but it's a losing position then and it's a losing position today. In Hampton and Co., they uphold the delegation of tariff-setting authority, but Taft drops this sort of ominous rationale that the political branches can avail themselves of the assistance of the other branches, but at some point delegation becomes an assumption of the other branch's power, and assuming another branch's power is unconstitutional, the non-delegation doctrine in an early form. These two cases are cited all over the place by the current Supreme Court. They're like Chekhov's gun. Is it unfair to vest the sins of the current court on Taft? I think Taft thought that he could confine this reasoning to the facts, but you can't. So, what is he doing in these cases, and is it fair to attribute?
So Myers versus the United States, this is the first time in the history of the court that they find a statute unconstitutional based on inherent Article 2 power, the inherent powers of the presidency. That's the case that Andrea is asking about. And this is a revolutionary case. Taft, as the former president, is writing to sustain the power that he had as president. It is not true that it is an originalist opinion. Scalia claims it for originalism, but Taft is quite clear in saying, I'm not saying that this is the law because that's what the first Congress did. I'm saying it's the law because it's the right thing to do, and here are the arguments. So I don't think it's fair to call him a proto-Roberts. He wasn't a proto-Roberts. He had much more respect for Congress than Roberts has for Congress, I think. But he does represent the consolidation in constitutional law of a shift toward the presidency that you're writing about. You know, if the president is going to be a different kind of office in point of fact, constitutionally that's going to find its acknowledgement, and Myers is a case where you see that happening. And if you think about Hampton, it's enormously liberating. I mean, the delegation doctrine had never been so generously interpreted before Taft. So you have to think about that as a movement toward acknowledging the legitimacy of administrators, not giving a limit to it. From the point of view of when he decides that case, that is an amazing license he's giving administrators.
Yeah.
You talked about the relationship between Brandeis and Taft. I recall reading a letter, I think it might have been when he was talking about Cardozo being on the court with Coolidge or Harding, where he says, in vetoing it, 2 Hebrews on the court is too much for our society. Am I correct in that?
Well, he says actually to Harding, I'm assuming you're not going to appoint a Democrat at this time. He is the best judge, but I'm assuming you don't want another Democrat. But he wouldn't have wanted Cardozo anyway for that reason. You know, he said, I don't want learned hand, because the verb he used, he said he would herd with Brandeis, and we don't need more of that kind. He applies that to learned hand, not Cardozo. Cardozo's too distinguished to herd with anybody.
Yeah.
This is a slightly personal question, but what was it like to do this? How did you do it in a practical way, right? John asked you a kind of abstract question about methodology, but actually, how did you do this? How did you sit with it? What was your method? What were the highs? What were the lows? Celebrating your experience.
So, you know, I was like a young I was like 2-3 years into law, you know, and Stanley Katz said, will you do this? And of course, I'm so flattered, I say yes. And then he says, oh, it's the Taft Court. And I thought, oh. I mean, nobody know anything about the Taft Court. In the 20s, like we all said, it's like, who cares about the 20s? So I was like oppressed for many years. And this was before there were like even computers much, you know? And you certainly couldn't get stuff online. So I went and I read all the Taft, and I highlighted them, and I had them in the trunk of my car, and my car was stolen, and I had to go. It was. I mean, this has a long history, and I'm not an historian. You know, I'm other things, but not an historian, and so I had to have all of these cross indexes. So when I thought about a topic, I would remember, because otherwise I have no memory. So how to make the indices so I would remember. And then after, of course, Evernote comes. It's much easier. You have all the documents. You can call them up. You can tag them 15,000 ways. And actually, the thing that allowed me really, in truth, to write it is I got a grant to digitize all of my archives, because it was all like, I don't know whether you remember the mimeographing. It was all Xeroxed. And I couldn't leave my office because I didn't have the material. But if you can digitize it, you can all put it in these databases, and then you can write anywhere. So that was like tremendously liberating. And I had this material, but we talked about the weirdness of the 20s. I didn't have a line because it was so confused in the 20s. Everything was a mess. You couldn't get a through line on any topic. And so how to shape it, that is what Trump gave me. But before then, I didn't know kind of like how to give it a form. And that's what allowed, and also kind of like anger, but form too.
Yeah.
I have a question about one of the jurisprudential tools the Taft Court uses to legitimate law, and that would be Taft and Van Becker discouraging dissenting opinions. Taft talks about how dissenting opinions can be egotistical. He also understood how dissenting opinions could be used by political opponents of the court. How will the story of the Taft Court be different if you see a lower rate of unanimity for dissenting opinions? And I'm curious if you could juxtapose the Taft Court to the Roberts Court, where we see really powerful dissenting opinions from the liberal justices, and also dissenting opinions that are questioning the Roberts Court's efforts to legitimate law, like Nebraska versus Biden, the Stu Lum case. Kagan is calling out the court saying this is not law. So I'm curious if you could reflect on both the Taft Court
Well, you see, this goes to the question that John was asking at the first. There's a practice of unanimity. Taft, of course, hates it, but if you look at the statistics, the unanimity rates are roughly within a range the same before Taft and after Taft. So it's not Taft who's the variable here. The variable is that somehow the justices are imagining that they need to be on board with the court. So what could explain that? And what allowed me to see that was when I got into the docket books, I could see that the rates of dissent in the conferences where they're spontaneously talking, they weren't that, if you talk about cert, cases that come up by certiorari by the 1928, the dissent within the conference is, 40%, 35%. That's in the range of a modern court. But those cases are 88% unanimous when they're decided. So what's happening is the justices are saying, I dissent, but I'm not going to dissent publicly. As Taft once said to Holmes, he says, I'll make the sign of the scissors to you, but not to the public, he says. And thousands of these correspondence where they say, I am not going public with my dissent. So now the question is, why? I call that the norm of acquiescence. Why do they do that? And I think they do that because they imagine the court as a court which has to have a final solution. That is to say, this is what Dan was talking about earlier, that it's a final appellate tribunal. And a final appellate tribunal, you need an answer. Somebody has to settle a dispute. And if you dissent, you're not doing anybody any favors because it needs to be valid with respect to the parties. So Taft actually does so many things. One of the things he writes is the first code of judicial ethics for the ABA while he's Chief Justice. And in that code, you don't dissent in a final court unless it's a matter of conscience. So 20% of the cases you get a matter of conscience, but mostly you don't. And what happens is with the Judiciary Act of 1925, the court is no longer a final appellate tribunal. So it loses what I call the authority of finality. And its opinions, it's now picking cases in order to shape the future development. So how does it have authority? It has authority only if people agree with it. And if it only has authority because people agree with it, then the ability to shape what the public should think about it, you don't need the authority of the court for that. Any individual on the court can talk and be part of the opinion formation that says, should this be a valid or invalid? And so you see the evolution of this norm of acquiescence into a norm of expression. By the time you get to Brennan, he says, my right to dissent is a form of expression. It's a First Amendment right. Totally different concept of being part of an institution. And all of that is made possible by the Judiciary Act of 25.
Nathaniel.
So thanks for this kind of revelatory session. This has been an awesome capstone, albeit one that was disappointingly non-aggressive for one that opened up as a Marshall McLuhan session. So I'm really interested in your idea that these judges are kind of positioning themselves in what they imagine the kind of popular sentiment to be, and that this kind of legitimating project is the central driver. I'm curious where these judges are getting their self-conceptions of what the public believes and how they understand, sources that they would look to for getting a sense of what the popular sentiment is. Because you have this reading of economic rights where, the public will come along. What they really want is prosperity. But you have prohibition where they're looking at other sorts of sources, maybe the vote for the Volstead Act. And then you have, this other case with race where they're looking at this kind of high-profile confirmation hearing and maybe kind of chatter. So I guess I'm curious, one, where are they actually drawing this from? And two, where are their ideas about where they should look for?
So the important thing to understand is it's not their idea of what public opinion is. It's not like when we say that, we're saying we get a public opinion poll and it's 67%, and that's what people think. They wouldn't have any idea like that. They just have the sense of what we are as a people. Paul Freund once said, the court should be influenced by the climate, but not the weather. So anybody knows the climate because you live it. And it's the sense of, as a participant in the culture, this is who we are. First person plural. So it's a deep sense, not for Holmes. Holmes is saying we need this as a Darwinian sense. There's no we in Holmes at all. It's all Darwinian, and what you have to do to survive, make an order in a world in which everybody's at each other's throats, very Hobbesian. But for the other three, for Brandeis, he thinks we're a democracy. That's what we are. and Taft thinks we're a place where people get rich, like my family. You know, this is what Americans are. They want prosperity, and in the 20s, that's not so. There's a wonderful letter that Brandeis writes to Frankfurter. He's listening to Coolidge's address on Washington's birthday. And I don't know, have you ever read that? It's a great address where it says, why is Washington such a great president? Because he was a great businessman. And Brandeis said, I wanted to throw up. The only time I felt worse was when I visited the hospital and people with smallpox in Boston Island. He said, I want to take a shower after listening to Coolidge talk about who we are. McReynolds, who's a Campbellite, you know, he deeply believes we are our beliefs and our norms. This is who we are. And so that's where they get that. The interesting thing about prohibition, when I said they're messy in response to Mark's point, so it's positive law. It meets the rule of recognition. It's an 18th Amendment to the, 18th Amendment is ratified more quickly than any other amendment in the history of the country. No one can understand exactly why, but it is. And so, of course, I'm going to obey the positive law. That turns Taft into a Holmesian. He is a Holmesian. He says it's the law, and we have to defer to the law. Otherwise, but he doesn't say that about social legislation, right? So he lives with this contradiction. I don't know exactly how or why, but I think it has something to do with upholding the law itself in prohibition. Whereas when he's striking down, you know, the regulation of mattress stuffing, he doesn't think that the rule of law is at stake, something like that. So it's complicated. It's like the rest of us, complicated that way.
The rest of us is a good way to end. This is a book that is it's a case study in the construction of a self-governing project. It transcends the genre of the Holmes devise to become, it's as if the Taft Court was just an occasion for Robert Post over 3.5 decades to deposit his genius and share it with us. Thank you, Robert.
Thank you.
There's a reception outside.